Hi, and welcome to today's Startup Signature Series program focused on chain of title issues with your patents. My name is Allison Schmidt. I am the hoster of this series. It's my pleasure today to welcome Priscilla Dodson as our expert speaker. Priscilla is special counsel at Convington and Burling in their Washington office. Priscilla is really a jack of all trades. She has significant, more than a decade's worth of experience in patent litigation, where she's focused, although not entirely, but primarily in the life sciences space. Priscilla has also done a significant amount of work with patent prosecution and strategy issues, as well as with intellectual property diligence issues, the types of things that come up when you're trying to seek funding for your company, for example, or you're trying to do a licensing deal. So Priscilla is really an expert in all of these areas, and we're very lucky to have her with us today to share her thoughts and really get you ready to go on chain of title issues, which are really, as you're going to learn from Priscilla, are a really important part of the puzzle in terms of making sure that your IP has the value that you want it to have. So with that, I'm going to turn it over to Priscilla.
Thank you, Allie. So my topic today is chain of title in the context of patents and patent portfolios. So before we even get into what chain of title is, let's start with why it matters. Why a clean chain of title is critically important to the value of your patent portfolio. In the context of conducting IP diligence in the potential acquisition of a company's patents, there are a number of important considerations depending on the particular circumstances. However, these are some of the considerations that are nearly always come up and are nearly always at the top of the list in terms of importance. So scope, validity, and chain of title, which is basically ownership. So scope is a foundational question, which is, do the patent claims sufficiently cover or protect the technology at issue? Validity is, do we expect the patents to issue over the prior art? If you have an application, is there going to be significant prior art such that you have concerns that the patent might not issue? Or if the patent is issued, do you expect that it will be susceptible to significant validity challenges? In other words, how strong is your patent? And finally, chain of title, which is basically an ownership inquiry. Does the company have a clean chain of title to the patents, or is there a significant risk of an intervening right? So of these considerations, scope and validity can be difficult to get right or to control. So with respect to scope, sometimes you need to file IP early on in a project before you really know what the scope of the final product will be. So there is some guesswork involved, there can be. And validity challenges to patent depend in large part on the prior art landscape, which you usually don't have control of. But chain of title, you do have control of, and you can get this right every time. And it does not take a ton of time, and it has huge value to your portfolio. It is well worth your time to get this right. So the takeaway here is that you can have a groundbreaking invention, patents that cover the scope of the technology, no significant validity issues, but if you have a chain of title problem, it can really drive down the value of your IP, and sometimes to the point where a potential acquirer is ready to walk away. So before we get further into it, here's an overview of my presentation. We'll walk through some basics first, including what do we mean by chain of title, and also cover some basics on patent assignments and recordation at the USPTO, which is all part of the chain of title analysis. Next, we have some examples to walk through showing you how this plays out in real life and how it can go wrong, how I've seen it go wrong. And we'll end with a short summary of takeaways and best practices. So let's start with what we mean by chain of title. In the US, where patent laws tend to be inventor-friendly, an inventor owns their invention by default. So to transfer their rights in the invention to a company, such as the employer who is filing a patent on the invention, inventors will assign their rights in the invention to the company. And this is typically done through a document called a patent assignment, which we will discuss in more detail shortly. The assignment from the inventor to the company transfers rights in the invention from the inventor where they originally reside by default to the company such that the company now owns the patent. And thus we have a chain of title from the inventor to the company. So note that other countries other than the US may treat this differently. So if inventors reside outside the US, they may not have default rights in their inventions. For example, in some countries, an employer will own the employee's inventions by default. So there's no assignment that is needed. It's also possible and sometimes preferable, as we will discuss, to write automatic assignments into an employee contract, such that even in the US, where inventors own their inventions by default, the inventions created by an employee within the scope of their employment can automatically assign to the employer as of the time of invention, such that the rights are already with the company at the time of invention. In this case, there is still a chain of assignment from the inventor to the employer. It's just that it happens automatically. In this case, you can still have a confirmatory assignment that is executed from the inventor to the company, for example, at the time of patent filing. But this is often just done for purposes of keeping a clean paper trail, or having something to report at the USPTO, which we'll talk about in a minute. Since at that point, the inventor actually doesn't have anything to assign at that point. They were already automatically assigned. So if they're assigning later at the time of the patent filing, they don't really have any rights. It's just a documentation, really. And there's another scenario where an employee may have an obligation to assign written into their employment contract. And in that case, the rights to the invention transfer to the employer at the time of execution of the assignment, not automatically, although there is an obligation to assign. And also timing of the inventor assignments or intercompany assignments can be important as well, as we'll discuss later. So the chain of title analysis is pretty straightforward when you are just dealing with the direct inventor assignment to the company, as was shown on the last slide. But it starts to get more complicated very quickly when you add more inventors, sometimes from different companies, and those companies maybe subsequently be acquired or merged with other companies, and perhaps patent rights may be transferred within different entities or subsidiaries of a single company, for example. So I'm showing here a scenario where it starts to get more complicated. So let's add 3 inventors. And in this case, the chain of title analysis looks at assignments from each of the inventors. So it's not enough to just have an assignment from one inventor or 2 inventors to the company. If you do not have assignments from all 3 inventors to the company, then the company will not fully own the patent. So for example, if inventors 1 and 2 assign to the company, but number 3 does not, then the patent rights will be jointly owned by inventor 3 and the company until and unless inventor 3 assigns. And this is important because if the company wants to sell this patent later on down the road, it can only sell what it owns, which at this point would be a joint interest in the patent with inventor number 3. And that's usually not attractive to a potential acquirer. The company who wants to buy the patent wants to own all the patent rights. So it's really important to get all of the inventor assignments. Okay, here's an even more complicated scenario. Just for illustration purposes, let's say that company A and company B are collaborating on an invention made by their respective employees. So inventors 1 and 2, let's say, are employed by company A, and they assign their rights in the invention to company A. Similarly, inventor 3 is employed by company B, and inventor 3 assigns their rights in the invention to company B. So at this point, the patent would be owned by both company A and B because the inventors have assigned all their rights. Now, let's say that company A buys company B's rights in the patent because they want to own the whole thing. And so company B will assign their rights to company A. So now the result is that company A owns all the rights in the patent. And then company A is able to sell the patent rights to company C such that company C can own all the rights. So this is an example of a complete chain of title that follows the original rights from the inventors all the way to the new owner, company C. And the important thing to note here is that there are many links in this chain. And if any of the links are broken or do not exist, then company C will not have the full rights in the patent that it thinks it is buying. Thus, a chain of title analysis has to look at every link following the flow of rights from the inventors to make sure that they all eventually end up with company C. And these scenarios can get far more complicated with many more links and thus much more potential for the chain to break somewhere. So let's step back and take a closer look at the patent assignment document that we've been discussing. According to the USPTO's Manual for Patent Examining Procedure, or the MPEP, an assignment is the transfer of a party's entire ownership interest, the entire bundle of IP rights. So I've given a quote here from the MPEP, and also according to the Code of Federal Regulations at 37 CFR 3.1, defines an assignment of patent rights similarly as the transfer by a party of all or part of its right, title, and interest in a patent or a patent application. Note also that an assignment must be in writing. It is a document. It will usually take the form of a patent assignment document that includes language transferring, quote, all right, title, and interest, or entire right, title, and interest, are very familiar common phrasings of this. Often a patent assignment will further specify particular rights within the bundle that are being transferred, including, for example, the right to sue for infringement, the right to further assign or license, and the right to claim priority to the invention in later applications. So this may seem simple enough, but I have definitely seen people get this wrong. For example, what if an assignment purports to transfer just, quote, right, title, and interest in a patent from one company to another, not quote all or quote entire right, title, and interest, but just the right, title, and interest. So in this scenario, did they transfer everything or not? And sometimes you can look to specific provisions that are included in the assignment document. For example, transferring the right to bring suit, enumerating the different rights as listed on this slide, for example. But what if less than all of the usual rights in the bundle of IP rights is specified? For example, what if the right to further assign is not specifically listed? There may be a question at this point of whether less than all rights are transferred. And if less than all rights are transferred, some of those rights still reside with the first company or with the inventor and were never transferred. And this can have real consequences in the end. If the right to bring suit was not transferred, for example, then the company that bought the patent or the second company that bought the patent from the first company may need to join the first company to have standing just to bring an infringement suit. So the takeaway point here is that while assignment documents can take different forms or use slightly different language, the important thing is that they need to include robust language that clearly transfers all right, title, and interest to avoid ambiguity in what rights were transferred. And for the sake of clarity, I wanted to make a distinction between a patent assignment and a patent license. So this language comes directly from the MPEP at section 301, which distinguishes between an assignment of patent rights and a license, which is a transfer to another entity of less than all right, title, and interest in a patent. For example, it may be a license to a particular field of use or a geographic area. A license may be exclusive, meaning that only one company has a license to the particular field or geographic area, or a license can also be non-exclusive, meaning that many companies have taken licenses to use the patent in the same field or the same geographic area. So up until now, we have not yet mentioned recordation or discussed recordation, but this is also an important piece of the chain of title analysis that we'll take a closer look at now. So assignment documents can be made a public record through the USPTO, and this is the process of recordation. Note that the USPTO does not make a determination of the validity or effectiveness of the assignment document. Recordation is merely ministerial at the USPTO. You fill out a form, identify the patent, identify the property, and they record it, and that's all. It's not, there's no kind of determination that you can point to that the USPTO made that makes it any more valid. So while recordation is not required to make an assignment effective, there are good reasons to record assignments promptly. Recordation of an assignment provides legal notice to the public, for one. For a patent to issue to a particular assignee, the assignment must have been recorded or filed with the USPTO. And importantly, the effect of recording assignment is that it protects the patent assignee from a subsequent third-party purchaser of the same patent if the assignment is recorded within 3 months. So that's the statute that's provided here on the screen on the slide. So while the patent assignment does not become void if we don't record within 3 months, the statute no longer protects the assignment in the event of a subsequent purchase. So the best practice is really to just record it within the 3 months. So here's an example of a scenario that plays out the effect of failing to promptly record an assignment. So let's say an inventor assigns their invention to their employer, company A, and the company does not record within the 3-month statutory period. The inventor subsequently assigns their invention to another company, company B. Perhaps there was a question of whether the inventor was obligated to assign to company in the first place, and company B came along and offered to buy whatever rights the inventor still held, if any. So company B gets their assignment from the inventor and records within 3 months before company A. And in this scenario, company B would have the superior rights to the patent by virtue of recordation, even though the assignment was executed first to company A. So the takeaway here is that it is the best practice to promptly report. Okay, so here's an example of what happens when you have an incomplete transfer of rights from inventors. This is a well-known case, and the example here, this case comes up in the context of patent licensing rather than assignments, which have been the focus of our discussion, but it's a classic illustration of the importance of making sure you obtain rights from all inventors. So this is a 1998 Federal Circuit case involving 2 companies, Ethicon and U.S. Surgical Corporation, or USSC, as shown in this slide. And it involves a patent covering safety trocars, which are used in endoscopic surgery. So Dr. Yoon worked with the technician Choi on the safety trocars, and Dr. Yoon subsequently applied for and obtained a patent. Dr. Yoon licensed the patent to Ethicon, and Ethicon turned around and sued U.S. Surgical for infringement. So that's at number 4 on the slide. U.S. Surgical then realizes that Choi worked with Dr. Yoon and may have contributed to the invention, even though Choi was not originally named on the patent. So U.S. Surgical then obtains a license from Choi because if Choi is found to be an inventor, then Choi has a joint ownership interest in the patent. The court subsequently determined that Choi was a co-inventor and thus did have joint and ownership rights that could be licensed. So at the end of the day, U.S. Surgical has a valid license to practice the patent and is not infringing, and the case was dismissed. So the takeaway here is that in analyzing ownership of a patent, it is very important to account for all the inventors, even inventors that may not have been listed on the patent in the first instance. Of course, this can get tricky if you do not necessarily know who all the inventors are. One practical way that companies can address this situation where they may not know who all the inventors are is to build an automatic assignment provision, which we discussed earlier, or an obligation to assign into their employment contracts, such that inventions created by employees within the scope of their employment will go to the employer automatically. And that way, if an employee is later found to have contributed to the invention, for instance, after the patent application is filed, their patent rights as an inventor will still automatically go to the employer without having to chase down an assignment. Okay, next are a couple of examples to show how even one break in the patent assignment chain can result in the end company who bought or wants to buy the patents. It can result in the end company who bought or wants to buy the patents not getting all the patent rights. So this is one of the scenarios we looked at earlier, where we have the 3 inventors from the 2 companies and everything eventually, hopefully, goes to company C. But in this scenario, there is a break in the chain of title. So inventors 1 and 2 are employed by company A, and they assign their rights and the invention to company A. Similarly, inventor 3 is employed by company B and assigns their rights and the invention to company B. So at this point, the patent is owned by both company A and B, not the inventors. Their rights have been assigned. But let's say that company A tells company C it owns this patent and that company C wants to buy it. But company C cannot own all right, title, and interest in the patent because company B still has a joint interest in it. It is not assigned yet to company A in this scenario. And so the result here, at the end of the day, is that the patent rights will reside with both companies B and C if you have that break in the chain. And here's one more example of a break in the chain of title. So if you have inventors 1 and 2 employed by company A, as in the same example, but only inventor 1 assigns their rights and the invention to company A. Perhaps this is an instance where a company did not realize the inventor number 2 was an inventor at the time the patent was filed and did not obtain an assignment. And so inventor 2 held on to their patent rights. Inventor 3 here is employed by company B and assigns their rights and the invention to company B. So at this point, who owns the patents? This is jointly owned by company A, B, and inventor 2, because inventor 2 never assigned. So company A, let's say, then buys company B's rights in the patent. Company B assigns to company A. So at this point, the rights are owned by company A and inventor 2. Company A then sells the rights to company C. So what is the result? Is that company C owns rights jointly with inventor 2 because inventor 2 never assigned. And this is a similar situation to the Ethicon US Surgical Corporation case that we discussed. So we talked a bit about automatic inventor assignments earlier, where an inventor's employment contract provides that any inventions created by the inventor employee within the scope of their employment will be automatically assigned to the employer such that the employer owns the patent rights. And I mentioned that it can also be the case in countries outside the US where employers are the original owners of their employees' inventions without any separate assignment. So in that case, a subsequent patent assignment by the inventor would be confirmatory only. It's illusory. It cannot transfer any patent rights because the inventor does not have rights left to transfer at that point. They already transferred at the time of invention. So I've included this scenario here to illustrate how the situation can play out and potentially cause confusion if you're not aware of it. So here, let's say that the inventor was employed by company A at the time of invention, and the inventor's rights in the invention were automatically assigned to company A at that time. However, let's say company A soon after spun out a subsidiary and the inventor became an employee of the subsidiary. So the subsidiary then filed patents at that time on the inventor's inventions and diligently obtained an assignment from the inventor to the subsidiary. So the subsidiary then sold the patent rights, let's say, to company B. So at this point, does company B have all right, title, and interest in the patent? And I think the answer here is maybe. The inventor's assignment to the subsidiary is illusory, as we talked about, because it's not really transferring anything. The inventor's rights reside with company A, since as of the time of the invention. So the real question is whether company A's rights in the patent transfer to the subsidiary, either through a formal assignment or by virtue of its relationship to company A that could then go to company B. So there's potentially a break here in the chain of title between the company and its subsidiary. So just one more note here. I think I had mentioned this earlier. What is the point of having a confirmatory assignment if his rights have already transferred? So why bother with executing this? And there are various reasons this may be useful. One is just to have a document that you can publicly record with the USPTO, because when you record, that is publicly done. So you're not going to want to put necessarily an employment contract, record that. So sometimes it's nice to just have a standalone document, even confirmatory, that you can record with the USPTO. Okay, here's a last example illustrating that timing of when assignments are executed can matter in some circumstances and sometimes very significantly matter. So let's look at a scenario where company A in the middle of the slide here files for a patent application that is based on work by two of its employees, say inventors 1 and inventor 2, and they filed the PCT in January 2025. And this application is a PCT, an international PCT application that claims priority back to a 2024 provisional application. So let's say the inventors are still with the company, so the company is not in a rush to get its assignment documents and recordations in order for the provisional or PCT application. This happens a lot. But then 6 months later, the company is interested in selling the PCT patent family to company B, and at that time, it gets its executed assignments from the inventors in order in July 2025. So this is well after the filing of the PCT. So the result here is that the inventor assignments are executed after the PCT patent is filed and after the priority claim was made. So the question is whether Company A had a right to claim priority to the earlier filed 2024 application when it filed the January 2025 PCT if the inventors had not formally assigned anything until July 2025. So in the event there's no automatic assignment, we'll assume, then the answer is that at the time the company filed the PCT application with its priority claim in January 2025, it did not own the patent rights because those weren't assigned until later, formally. So is this a problem? And how much of a problem is so? And the answer is that it depends on the jurisdiction. So while the US takes a more lenient view, some jurisdictions around the world take a very strict view of priority claims and require that the applicant of the PCT and the owner of the provisional application to which the applicant is claiming priority to be the same entity. And if they're not the same entity, then the priority claim is not valid. And this would be a problem in the scenario here because Company A did not own the 2024 provisional at the time the PCT was filed. The inventor still owned it. They had not assigned. And in this case, the national stage applications filed off of the PCT in certain jurisdictions that are very strict about the priority date may not get their priority date. And this would mean that if you don't get your priority date, intervening art between the 2024 priority date and the January 2025 PCT application could become prior art to your application and be used against your application in those jurisdictions. So the takeaway here is that the best practice is to promptly execute assignments. Okay, now we're getting to our summary slide. So I'm just showing one of the scenarios we looked at earlier, showing the generic chain of title from the inventors to an acquiring company, in this case C. And I hope that I've convinced you that each link in this chain of title matters and the value of your IP portfolio may depend on you getting this right. And I've highlighted some of the ways in the next slide of I've highlighted some of the ways in this presentation that this can go wrong and provided some best practices on the next slide for avoiding some pitfalls. So as a takeaway, I've summarized some of the best practices we've discussed. So robust assignment language, clearly assigning all right, title, and interest is important. Recording within 3 months of the date of assignment may save you from a subsequent purchaser of patent rights. If feasible, there may be a benefit to drafting employment agreements to include an automatic assignment of the inventor's patent rights. And as the last example we looked at showed, it is important to execute assignments promptly.
Thank you very much, Priscilla, for this excellent program. This is going to be required viewing, I think, not just for startup companies who are engaging, but also for many of my students who will be heading into these fields. So thank you so much to our viewers for joining us. We really appreciate your engagement with the Startup Signature Series. Stay tuned for our next set of programs.